So we'll go ahead then on Harrison versus Blue Cross and Blue Shield, 231676. And again, counsel, would you like to reserve some time for rebuttal on this case?
I will do my best to adhere to my request this time and would ask for 4 minutes for rebuttal, sir.
4 minutes on the case. Thank you. So noted.
May it please the court. Again, Michael Orr on behalf of the appellant. In understanding there are a number of issues in this case, we would like to address 2 points today. One, that the trial court incorrectly applied this court's prior opinion from Harrison 1 in its order of dismissal, and second, that the administrative proceeding does not act to preclude the claims under the legal doctrines of res judicata or collateral estoppel. As to the first argument, Your Honors, and Judge Tannenbaum was addressing this earlier with the prior appeal, we have this opinion that Judges Winokur and Jay and Thomas wrote, and both the state and the appellant requested clarification, and an opinion was substituted. And that clarification was meant to try to understand what are we doing when we go back. And with the opinion that we got, as Judge Tannenbaum noted, it said, we affirm without comment, except for, as we're discussing here, in finding that there should be reversible, or there was a reversible error here because there was no leave to amend granted. And there's a practical component to what that panel did with the opinion. They're not going to, no appellate court's going to prejudge legal arguments on a non-final order when the complaint is being amended, because under Florida law, once you amend the complaint, those claims are abandoned. And so what the appellate court was doing was saying, this is reversed, leave to amend should have been granted. But here's the significant piece from our vantage point that we believe has been lost. In that opinion, the court states its finding and says, one of its findings, that we further find a factual dispute existed which was not appropriately raised or resolved on a motion to dismiss. And they say, we further find that appellant's proposed amendments are not futile. Footnote. And then we have footnote 2. The argument from Florida Blue in their brief is that what follows in footnote 2 from that panel is all dicta. And Your Honors, our position is Judges Winokur, Jay, and Thomas did not write that entire footnote explaining their holding with citations to case law and the arguments to give dicta. They were providing the analysis and the basis for their ruling.
Well, let me make another suggestion. Perhaps it's not dicta, but perhaps it relates only to the bad faith claim, which was asserted in the first amended complaint, but not in the second amended complaint. They start, we note, with regard to appellant's bad faith claim, and then go on to the rest of the paragraph. So how do we know that this, or how should we read this such that it relates to more than just the bad faith claim?
In Your Honor, the way I read it, I believe that's the first sentence of the footnote, and then what they've essentially done in that footnote is address the arguments that Florida Blue was making, one of which, a significant argument that they've made again to the trial judge, and the trial judge adopted in its order of dismissal that Florida Blue provided, is that because they are a third-party administrator and not an insurer, that they have no duty to the appellant or to policyholders, state employees. The judges, the panel from that Harrison 1 opinion expressly rejected that and said it's too early to make that determination at the pleading stage, and pointed to the allegations from our complaint, which exist in the second amended complaint, that there's an agreement between the state and Florida Blue that in a particular time period, a given year, if they pay out claims over and above a certain percentage, I believe it's 105% of what's taken in for premiums, that Florida Blue is on the hook for that. And so what the court said in that footnote is this determination that there's no duty owed to the policyholder, to Harrison, it was too early and should not have been resolved on a motion to dismiss.
But, I mean, duty, though I don't believe, and it's a long footnote, but except in the parenthetical with Cole, I don't think the word duty appears, right?
That's correct, Your Honor. It says, what they say is a factual dispute existed which was not appropriately raised or resolved on a motion to dismiss. And so they specifically found that this argument from Florida Blue that it's just an administrator, not an insurer, should be rejected.
What do we need on the duty issue, not even with the law of the case, but if we're just looking at the duty issue fresh, what do we need more besides 110, 1235, and the attached plan that's part of the record here? What else do we need to determine whether a duty exists?
I think if the court, the trial court, were to accept the well-pled allegations of the complaint, there is no more that's needed to find that there's a duty. But understanding that duty is a legal issue and the court can determine it, that's typically something that's determined on summary judgment. In this particular instance, we would like to have discovery as to the relationship between the state and Florida Blue and that contract and what the actual inner workings are and responsibilities are in accord with our allegations that Florida Blue takes on a lot more responsibility and does a lot more than perhaps just the plan suggests that they do.
But how is that relevant? I mean, what the relationship is between Florida Blue and the state, or what the contractual relationship is between the two. Where's the contract relationship between your client and the state, or between your client and Florida Blue?
And I think it's in the record somewhere around 995 or 998.
I'm just relying on your complaint. I mean, I'm looking at the Second Amendment complaint, and I'm looking at the attachments. So
Yes,
where, and then maybe start with the first couple pages. What was it? Record page 998. If you can explain explain how you get around the statement on that page that Florida Blue is exactly what it says it is, and which is in your complaint, that it is a third-party administrator. It doesn't make any final decisions about claims, coverage, benefits, anything. That is ultimately, finally, and exclusively the realm of the Department of Management Services, DSGI.
And our allegations, Your Honor, are such that even though the plan booklet states that, in reality, what
And the
happens...
statute says that as well, yeah.
I'm sorry, Your Honor?
And plus the statute.
Yes, sir. And despite the fact that they say that, our allegation is that in practice what happens is a state employee has a choice between several plans that they can choose from. They can choose a plan, in this particular instance, the PPO plan with Florida Blue. They get a card from Florida Blue. They're told that they can contact Florida Blue. Their plan, for all intents and purposes, is a Florida Blue plan, and all their communication is with Florida Blue. Florida Blue is the one denying and making decisions. Now, from that point, the argument on the other side is, well, now we're just an administrator, because that's all that stuff really is. We're just an administrator, we're not an insurer. And that's what they've been arguing and argued on the first appeal. And what we said is that's not the case. We're arguing in the alternative that you are an insurer because under your agreement, your contract that you have with the state, you have obligations to pay out of your own funds for claims for benefits after a certain percentage. And so despite what the statute says...
That's not really the definition of insurer, though. I mean, that's not the same as accepting risk and having, capital back that up. That's pursuant to an administrative agreement between the state and Florida Blue, pursuant to statute that requires all of this. I still don't see when the statute says that these are TPAs and TPAs alone, and that the state, and it's coming out of sovereign funds at the end of the day, and that it's the state that's the ultimate determiner of these benefits. How does that change? How can you change the relationship by argument what the statute says expressly? And the documents attached to your complaint say expressly.
Absolutely, Judge, and quite frankly, it happens all the time in litigation where a statute provides for one thing as to how things are supposed to happen, and then in practice or reality, they're done a different way. And so that's what we're suing over. We're suing and saying
You're
that
suing
Florida
to change
Blue.
the meaning of the statute? Or
No,
you're
sir.
suing to ignore the statute and say there's this other theory?
No, sir. What we're suing and arguing is that exactly how the prior panel of this court analyzed in its footnote, that it's too early at the pleading stage on a motion to dismiss to determine whether or not the relationship between the parties is such that Florida Blue is not an insurer in this scenario and is only a third-party administrator. And so that's our argument on appeal. Here, what the trial court did when it entered its order of dismissal, the trial court expressly ignored that entire paragraph. Doesn't address it anywhere in the order. Doesn't address the finding from this prior panel as to those issues. Completely ignores it.
Was that footnote necessary for the disposition?
Absolutely, from the standpoint that it provides the analysis for the holding that the court provided.
But the court didn't remand and say reinstate the First Amendment complaint that had been dismissed. It said the error was it was dismissal with prejudice, that the trial court abused its discretion. That was the error. It abused its discretion in not allowing you to amend your complaint at request.
Yes, Your Honor. And as to this footnote, what the actual sentence, the holding was, is further we find that the proposed amendments from the appellant were not futile. So that's why it's very important that the court explain what the amendments are, what the claims are that are not futile. That's what the analysis is in the footnote. These are the claims that should not have been decided at the motion to dismiss stage, which is exactly what the court did
Well, so
when it went back
what
down.
did we affirm? Because I've got the original order here somewhere. What out of that original order on the first amended motion to dismiss, or the motion to dismiss the first amended complaint, what did we affirm without comment the trial court's order?
There were arguments that related to the state when there were other claims against the state that were affirmed. The arguments that were not addressed in the footnote and the analysis from the prior panel. The sentence that Your Honor read from the very first line of the footnote, the insurer bad faith count. All of those things that are not found in the second amended complaint is what was affirmed. Now, I know that the motions for clarification that resulted in that substituted opinion, this issue that we're all arguing over here today, and much of what Your Honors will see in the transcript on the hearing on the motions to dismiss, was trying to discern just that, Judge Bilbrey. We were all trying to discern what
One of
was
the
it.
things- And I found in my stack of papers here, I found that order on the motion dismissing the First Amendment complaint. One of the things there was, or I guess two of the things, res judicata and collateral estoppel, which is not mentioned anywhere in our opinion. So did not then the Harrison 1 opinion affirm the findings of res judicata and collateral estoppel from the trial court on the First Amended complaint?
We would suggest they didn't, Your Honor, only because, and this touches on what Judge Tannenbaum said earlier, and I'll give an analogy. When a court PCAs an opinion or an order, there's no precedential value there. There's no analysis
That's different
addressing.
than the law of the case. If
That's true.
I mean, the case is for, whatever the trial court did, if we said, yep, we affirm that, that's locked in unless you're trying to show a manifest injustice, which is not alleged here. So, what we affirmed, whatever that was, if anything, is locked in, right? So I don't think the PCA analogy, which I understand what you're trying to say, but I don't think that's analogous.
And Your Honor beat me to my second sentence, which is the only difference is when you have an affirmance without comment or an affirmance without analysis, that it can be law of the case and there can be an argument that relates to res judicata as to certain issues. But
Can a PCA affirm trial court findings in an order of dismissal with prejudice?
I think
What is that?
That's a great question, Judge. My understanding is the District Court of Appeal, if it was writing an opinion and specifically detailing what findings it was affirming, perhaps it could do that. But generally speaking, it's affirming a judgment, an order, a decision of the court, or reversing that decision of the court, and with or without analysis. And so in this particular instance, it's not like we're all here with an order from Harrison 1 or an opinion from Harrison 1 where they go through each finding of fact of the 30-some-odd legal arguments that are in the motions to dismiss and says we agree with these and don't agree with these. And that's frankly, again, because, as Your Honors noted, Judge Tannenbaum, this was a non-final order where they just said you should have allowed a leave to amend. And by the way, the proposed amendments, which are in our brief, we pointed out, were not futile. And that's what the appellate court was addressing in Harrison 1. You should have allowed amendment. And I recognize that we have this affirmance that muddies the water because now we're arguing what did we affirm or not affirm. And our whole argument on that, Judge Bilbrey, is there'd be no point to reverse the case and allow amendment if it was just going to be affirmance as to res judicata and collateral estoppel, because there would be no claim. And I see that my time's
Thank you, and we'll give
about
you
up.
4 minutes for rebuttal then. Thank you.
Thank you, Judge.
And we'll add 4 minutes to the appellee side also. Apologize again for the seating confusion. I thought there more folks would be coming up.
It's just me, Judge.
That's okay. We'll have questions for you anyway.
May it please the court, I'm Tim Connor from Holland and Knight. I'm here representing Blue Cross Blue Shield of Florida. And as I've listened to the questions from the panel today, obviously there's a number of questions, a lot of issues in the case, and you know, it's kind of hard to just, you know, try to put a bow on everything in this case, but I'm going to try my best to do that. So, as Your Honors know, there's a long history to the case. There was an appeal process. There was an administrative law judge hearing. There was an evidentiary hearing. The conclusion of that entire process was that the plaintiff's claim for benefits was properly denied. So now we find ourselves in circuit court dealing with what is essentially a challenge, a collateral challenge to that issue. Let me start off by talking a little bit about the law of the case, because that is one of our principal arguments, and we believe that is a really important argument here. And as some of the questions that you've asked have elucidated on this issue, we're looking at what was the first order of dismissal. This is the Judge Dotson order. And what was the opinion of this court with respect to that order, and how do those two things relate to each other? And then how does that relate to the entirety of the case? So I think if you look at what this court did previously, and I believe that, you know, when you look at court opinions, you look at what is the holding. Obviously, we've argued the footnote is dicta, which is what we believe. But the words that are used should be given their plain meaning. And they're not words that I think in this instance are wasted in any way.
Was there anywhere in the opinion, did it say, as to counts, fill in the blank, 1, 3, and 5, the dismissal with prejudice is affirmed, and as to the remaining counts, we reverse with the direction of the trial court to allow an amended complaint? Was that said anywhere in the-
There are no words like that,
Right.
but
Would that not have been a better way to accomplish
well.
what now you're trying to take advantage of as law of the
No.
case?
Well, no, Your Honor. I think the words are straightforward. Now, I'm not in the business of telling the appellate court how to write a better opinion, but if you look at the words beginning in the bottom of the first full paragraph, this court says, "We affirm, without further comment, the trial court's order with one exception regarding the trial court's implicit denial of appellant's motion for leave to amend. We reverse and remand for further proceedings consistent with this opinion." So what I take that to mean is that this court agreed with what Judge Dotson did substantively in his rulings on res judicata, collateral estoppel, and the other issues that are outlined in that order, except Judge Dotson did not grant leave to amend. Now, the leave to amend was not a motion for leave to amend. It was a statement in another paper, and there was no proposed amended complaint. So that was one of the things that we argued about a little bit when we were arguing about the motion for clarification, because there was no proposed amended complaint, and it's something that we pointed out in our papers. You don't know when we go back, is there going to be something that's viable or not? The futility doctrine, which is referenced, is obviously a doctrine that's been around for a long time, and which basically says, look, we're going to give people a chance to amend unless we conclude without any doubt that it is impossible to amend. So we're going to at least give you that chance. And the plaintiff had not abused the opportunity to amend, and there was no finding by Judge Dotson of futility. So that just wasn't there. And this court said, look, we don't think it's futile, okay? But in the footnote that we've talked about, the court said, and this is at the very end of the footnote, to this end, appellant should have the opportunity to attempt to amend the complaint as to all claims against all defendants. However, while any amended complaint must adhere to this court's opinion, we do not conclude that appellant can state any particular cause of action. So, in my reading of that opinion, I believe that it's straightforward. I believe that what this court did is it agreed with the substance of what Judge Dotson said in his order. On the procedural issue of should there have been a right to amend, this court said, we think the opportunity should be given, not summarily denied as it was in this instance. And we will send it back for that purpose. The plaintiff is free to amend it as to all claims, all defendants, however it wishes to do it.
But that seems to cut against, so what you're arguing is that, well, this court affirmed, whatever Judge Dotson's reasoning was in his original order. But then it says, but they can amend their complaint as to all the counts, which
Sure.
means that what he said really didn't. How do you reconcile? That just seems terribly inconsistent.
I don't think it's inconsistent.
Or not to say
at
that
all.
you're being inconsistent. How do you reconcile those two ideas?
So, well, the
unless-
way I reconcile it is that substantively, this court was agreeing with what Judge Dotson had done, but on a procedural issue, the futility issue had not been addressed by the trial court. This court was not willing to say it's futile. Therefore, we're going to give the opportunity. Now, that doesn't mean you go back with a clean slate as if nothing ever happened. That doesn't mean you go back to the trial court and the issues of res judicata, collateral estoppel, lack of standing, et cetera, that were in Judge Dotson's order go out the window.
But at
It
least
means
it's-
you take them into account when you do the amended, I'm sorry, Your Honor.
No, but at least as to the breach of contract action, you know, if we're saying the collateral estoppel and res judicata are still there, but they can amend, we said in the opinion, amend on all claims and against all defendants, like Judge Tannenbaum was saying, that just seems inconsistent. How can you go back, at least on those counts, which were allegedly, you know, previously adjudicated in the administrative action? It just seems like we've created some kind of inconsistency there.
Well, I mean, you know, look, I agree that it is difficult to go back and amend the complaint to get around some of these issues, and that's why we're here today, because that wasn't able to happen. But we have significant legal issues that bar these claims, whether we're looking at Judge Dodson's order or the current order under review. I'm not here to tell you that the plaintiff could amend the complaint because, frankly, I don't think that they could. I don't think there's a viable claim in the case, period. But that's my opinion as the lawyer for Florida Blue in this case. And so I think that this court was saying, give the opportunity, but there's no guarantee that you're going to be able to state a cause of action.
Did Florida Blue participate in the DOA proceeding?
Yes. Yes,
a
Florida Blue
party?
did actively participate, Your Honor. So
I mean, was it a party?
it was not a named party, but it was,
So it
and
wasn't
this,
a nominal party?
it was not a nominal party either. So, you know, in this context, Judge, the way the statute, I mean, you've asked questions and you've obviously read the statute and the plan, and I think it's pretty straightforward. But, you know, the way the administrative proceedings work, it's an evidentiary proceeding. A lot of the evidence has to come from Florida Blue because Florida Blue is the third-party administrator. So the questions are, well, you know, what did you, Florida Blue, what did you do? How did you handle this claim? How did you come to the decision you came to on that level 1 appeal that they're responsible for? And so if
I mean, the reason
Yeah.
the reason I'm asking is the same question I asked your other counsel for the department. How is it that an administrative hearing officer in the executive branch can issue an order that can bind in some way the judicial power of the state in a court of law?
so,
Without the legislature specifying something
yeah, so
otherwise, or, I mean, to put it to address it from both directions, why is that not actually some sort of sovereign immunity issue or something else? Like if this is, or an unauthorized lawsuit against Florida Blue in some way?
Yeah, so I think that comes out in our argument, Judge, about exhaustion of administrative remedies, that the legislature passed this statute specifically to create the plan, and as part of that said there will be this administrative process. And that process is the exclusive process for resolving disputes about whether the claim should be covered or not. So I think it's intertwined with that issue. And we've argued in our papers, and we argued below, that there was a failure to exhaust administrative remedies because after the ALJ's decision is adopted by the Department of Management Services, the only thing that we believe the plaintiff could do here is appeal to this court.
But even if, let's say they did that, and I still don't understand how the exercise judicial power can be part of the administrative process, but let's assume that they did take the appeal.
Yeah.
And it was affirmed. So now they've exhausted their administrative remedies and now they can sue?
No.
Right. The answer is no, because
Yeah.
what the first thing you said, which is there's this, it's a public right established by the legislature. You can only sue the legislature or sue the state or proceed against the state in the way that the legislature directs, and the only way the legislature is directed is through the administrative process. That's the only route that they can proceed against or through to seek relief, and they did that. regardless of whether they took the appeal or didn't take the appeal, it doesn't seem to be an exhaustion issue. It seems more to have to do with the fact that there's not a legal cause of action for relief against Florida Blue under these scenarios with the documents that were attached to the statute that's present.
Yes, sir. I would answer that. Number one, I agree with that. I don't think there is a claim against Florida Blue that can be made outside of that administrative proceeding with respect to the state group plan and how claims are administered under that plan. That's number one. Number two, I think the fundamental principle that you're raising is what we raised within our argument about the failure to exhaust. So it maybe is expressed a little differently than Your Honor might express it, but I think the principle is the same. You can't bring a suit in circuit court over these issues because your remedy is over here in the administrative context.
I think this court recently addressed this issue, at least a little bit in Wester, if I'm not mistaken, and I don't know how much you read that or like whether this has any effect, but that's where I'm having trouble understanding why we keep talking about exhaustion as opposed to whether there's a viable theory of relief against Florida Blue in the first place.
Yeah, well, I think the answer is there is not a viable theory, and maybe
presumably there's not a viable, there's certainly no statutory basis to proceed. The legislature has not set out a vehicle by which to seek a public right against Florida Blue in circuit court, which would leave presumably some just common law theory, which I think is all they've been proceeding against in the Second Amendment complaint. So then what's the question, why can't we address that question, whether there's a common law theory that they can pursue against Florida Blue?
Yeah, well, I think at the end of the day, if you talk about what it is that is actually being achieved by a claim that's being made, it has to be that our claim was wrongfully denied. So the claim for the residential treatment in this case was wrongfully denied, and that decision has already been made. So if the decision was, that claim should have been paid, ultimately the funds come from state tax dollars in any event. So I think, we've made these arguments about the failure to state a claim and that there is no claim, et cetera, for a variety of reasons. And maybe the argument is a little bit different than maybe the way Your Honor might express it. But I think we get to the same point of saying there's not a viable claim here, either way.
There could be, I'm not saying there are, but in hypothetically, in the realm of common law actions, there could be some tort theory to proceed against Florida Blue. Let's say Florida Blue negligently misrepresented something about how this process works, and it caused them to rely on it, you walk through the elements of that. Or let's say that Florida Blue behind the scenes is tortuously interfering or doing something to interfere with their effort to get a public right. Mm-hmm. In theory, that could exist, right? I'm not saying you're not conceding it. It's not necessarily foreclosed just because this has to do with a claim under insurance that's already been denied through the administrative process. It may be they haven't expressed it in their Second Amendment complaint. Those are two different things.
So, I'm hesitant to say, hypothetically speaking, there could be a claim, because I think the answer to that question is no. Is there a set of facts that I'm not aware of where, possibly there could be a claim? I don't know the answer to that. I don't know exactly how to answer that other than analyzing the facts that are in front of me. So I don't want to concede that there would be some basis for a claim. I just know that in this case there's not.
Right. These allegations,
yes.
Maybe. I guess that's your argument.
Yes.
And this is their Second Amendment complaint, so it's not like they haven't had chances to assert these other theories. So I'm not asking you to give anything away. I'm just conceptually, is the focus still, the statutory avenue, the public right to get some sort of benefit from the state treasury, which the legislature controls, or is it some common law theory where they're coming after Florida Blue and its pockets, independent of
Yeah.
the state treasury?
Yeah. Yeah, well, I don't think that that is this case. And I think that a number of our arguments actually, sort of deal with why that's not in this case. So if, I don't know if I need to address the trial court exercising independent judgment here. You've talked about that, and there's been a number of, I think absolutely Judge Marsh exercised independent judment here.
Well, I mean, does that even matter?
I was going to say, Your Honor, first of all, I think he absolutely did. I think there's no question about that. But I think secondly, I don't know that it matters that much, because if you agree with the decision, then, you should affirm. And the legal explanations that are laid out in his decision, I think, are straightforward and should be affirmed. If you disagree with the decision and you think that he's absolutely wrong about these issues, then, presumably you would send it back and say, we think you were wrong. So I don't know that it necessarily matters when you get right down to it. As you said, he could have entered an order just saying motion granted without explanation. And then we would be here arguing about all of the reasons that were raised below that could be the basis for the decision. And it's, I'm running out of time to address my other arguments. So I have obviously a number of things that I want to get to, but I see that I'm out of time. So I just want to conclude by suggesting this. We think that all of the arguments that are set out in our brief are very straightforward arguments about this case, and whether it's a law of the case issue or there's confusion about what happened the first time around, and you go to, okay, well, if law of the case wasn't there, how do we deal with the other issues? And we've addressed that in our brief. There are 5 things that I think you should look at. The first one is the first trial court order. The second one is obviously the first opinion here. The third one is the actual second amended complaint. I think you should lay that against the administrative law judge's decision and look at the findings, because all of those take out each of those findings in that second amended complaint. So they've already been adjudicated. And then finally, obviously, Judge Marsh's order here, which we think is correct and should be affirmed. Thank you for the extra time.
Thank you, counsel.
May it please the court. I want to address the question that Judge Tannenbaum raised to counsel about, well, couldn't the plaintiff in this case, the appellant, have a common law claim against Florida Blue, not prejudging whether they've pled it right or not in this particular instance, but would they have one? And the answer from counsel was no, but there was no explanation, and there's no explanation anywhere in the brief. And there was no explanation from the trial court below. The fact remains that a class claim, negligence, negligent misrepresentation, an injunctive relief claim, none of those claims can be filed in the administrative case. None of those issues can be resolved by an administrative law judge. And in fact, yes, sir.
I agree with you. What do we look to? A lot of those, though, presuppose a duty, right? You got to have a duty as an element of, negligence at least. Where do we look to besides the operative statute and the plan to find whether a duty arose to your client from Blue Cross Blue Shield?
Your Honor, the well-pled allegations of the second amended complaint, where we describe at the beginning of the complaint the relationship between the appellant and Florida Blue and what the relationship was there. And I believe it was either the Hotchkiss or the Cole case where the court said dealing with that issue on a motion to dismiss was premature. So it's our position, Your Honor, that we've pled that there is a duty based on the relationship, based on the fact that they are an insured. They're effectively making healthcare decisions. A number of state employees that would be members of this class, there are varying levels of pay certainly for state employees, but the ability to have an approval of a healthcare decision and have a claim approved or denied for many people is effectively a decision on whether you're going to get the healthcare treatment that your doctor's recommending. So we've pled in this particular instance that there's a duty owed to administer the claim fairly, to follow the plan, to follow the statute, and not to use undisclosed information or criteria. And that, we believe, is critical. We're not suing, and
But
this
they're
is...
ultimately not responsible for that. That is by statute, that is the Division of State Group Insurance that is ultimately responsible for all those decisions that Florida Blue may be making that, your client, others may not like, but that's ultimately the state that's responsible for that.
Ultimately, the state is responsible and is the final arbiter and gets the final decision-making, and that's why the administrative process involved the state as a party. Your Honor's correct. And so the way it worked is the claim gets submitted to Florida Blue. Florida Blue denies it.
Right.
Florida Blue, there's an appeal to Florida Blue. Florida Blue responds again and is relying on criterion information outside of the plan, outside of what was agreed to, the benefit of the bargain, when our client chose
Well, wait,
the
what's the
PPO,
bargain? What's the bargain?
paid a policy premium for a PPO plan with Florida Blue. And
Well,
so
that's by state, that's a directive from the legislature as a state employee. The deal is that the state's going to pay most of your premium. Well, it's not even a premium. The state's going to cover your claim, and there's an expectation that the employee is going to cover some of that cost through a holdback in their pay. It's
And
not
so-
quite the same thing as paying a premium to a private insurer.
And so I'd point out, Your Honor, we're here on a motion to dismiss stage. All of these things are not even in the record at this point. What we
But they
have...
are in the statute. That's why I keep asking about the statute. You can't get around the statute. If it says it's X, you can't say, well, but it might be Y. It is just X because that's what the statute says.
And that would be more appropriate for an affirmative defense and then a motion for judgment on the pleadings or motion for summary judgment, and not a motion to dismiss that's confined to the four corners of the complaint. And looking at I see that my time's about to expire. May I
Go ahead and
respond?
conclude for us. Thank you.
Your Honors, the motion to dismiss that, and the corresponding order from Florida Blue in this case, and the order that was striking class allegations, both of which were unedited, relied upon statements and argument, and we've set it out in the brief, that were expressly rejected in Harrison 1. And on top of that, the court states that we're seeking the same relief from the administrative case, which is we're seeking the denial of benefits. I want to make abundantly clear to the court, a review of the second amended complaint, nowhere in there do we say we are seeking the denial of benefits. We are seeking the amount for the medical treatment, which is what they've argued and what the trial courts adopted without citation to anything in the second amended complaint. And that's the problem with these orders. They go outside the second amended complaint and the well-pled allegations, and they rely on issues, argument, and evidence outside the pleadings. This court should reverse and should direct Florida Blue to answer the complaint. Thank you, Your
Thank
Honors.
you, counsel. Thank you both for the arguments. We are adjourned.